Two defendants. Two shocking court moments. One judge trying to keep complete control of the courtroom. But what happens next could change everything. Watch closely, because every word matters in this case.
Good morning. You're Regina Williams-Jones. And Miss Williams-Jones, you've been here, it looks like before, in cause number 25, DCCR 1430. And now there's also another offense that was indicted in cause number 26, DCCR 0218. And that offense, you're also charged with the same thing, theft of property with previous convictions. And so since you've made bond in each of your cases now, have you had an opportunity to try to hire a lawyer?
Your Honor, I'm appointed, and,
Right.
and it had it as wasn't the designation. I think maybe because the second case got filed, maybe why it's back on the designation. But I had an announcement on
Oh,
mine.
she qualified? She wasn't qualified.
I don't know. I just had his announcement. I just
on.
talked to her this morning. But I hadn't talked to her, so I'm not sure.
Let me look at the 25 case.
I just had that.
Good. She's qualified. I'm not sure why that.
Okay. Well, I just talked to her this morning. I haven't had
Okay.
time to get to her, so.
That's fine. So, Miss Williams, once you bond out of jail, I expect you to try to hire your own attorney. And so you were here before and given some time to do that, correct? And did you hire him or you not yet?
I have to wait for my check to come and get Social Security.
Okay. If you get Social Security, you are likely would qualify for a court-appointed lawyer. Do you want to? You're fine with that. So I'm going to find that you qualify for a court-appointed lawyer. Mr. Parker will remain your attorney. We are going to go ahead and reset your case. If you'll step in front of the clerk, she'll give you his information so you can call him and make an appointment to go visit my charge. Speak up. I'm sorry. Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? The indictment also alleges you were previously convicted of driving while intoxicated April 1st of 2004, and then October 26th of 2007, and then after that, December 4th of 2015. And are all of those prior convictions true?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Judge Walker? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement is for a 10-year term in prison that would be probated for 5 years.
It's backwards. Should be 5.
Oh, 5 years probated for 10
Yes.
years. Okay, y'all are going to have to explain that one on a DWI 4th. I don't.
Wait, 10 years probated over 5 years.
That's not what's written here. What's
Okay,
written here is 5 years in prison, probated for 10, and
That's transposed.
It may be.
so 10 years. So it'd be violating.
Yeah,
So
10
it'd be the whole 10 years of it.
Probation. Yes, ma'am.
5 years probation, 10 years in prison.
Right.
Correct.
That's our agreement. Yes.
Okay, that makes sense. Got it. Everybody okay if I make that modification?
Absolutely.
Thank you.
Sir.
Thank you, sir.
Well, Mr. Parker for that.
Yeah, I think it's probably Alan's fault.
And do you have that attachment for this?
Judge, he wrote it out on the back.
Oh, okay, perfect. Thank you. All right. And so now it looks like the agreement that you have reached with the district attorney is for a 10-year term in prison, but that would be probated. You'd be on probation for 5 years. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? And y'all wrote on count 1 only, but I think those prior counts are necessary for jurisdictional purposes, correct? I mean,
I think to play true to the honor.
yeah.
Yeah.
Okay, because there is only technically 1 count.
Right.
Okay, just making sure. Do you also understand, sir, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Is that right? One of them looks like I don't want to, so we've got 2 priors that were,
Judge, I think the
Misdemeanors.
confusion is the way we list the prior DWIs is more of a
paragraphs, but the
It's
last
helpful, yeah.
paragraph, it looks like is an actual
it is, Your Honor.
felony,
It is.
but it says relating to a driving while intoxicated second. Was it reduced? I don't want it to be true to something that would actually enhance it up to a second.
Well,
Y'all know what I'm saying? That last one.
Judge, just for purposes of the record, we are pleading true to 2 priors.
2 priors.
For jurisdictional purposes only.
Okay.
and I'll tell you, the last one looks like a reduction, Your Honor.
All right.
it's a
So
misdemeanor.
what I'm going to do for the record is take those pleas of true on the first 2 enhancements, and then just waive the third one so that there's no issues.
Thank you.
Perfect. All right. And so state tenders number 1,
No objection.
it's admitted. Is there any evidence that Mr. Ward is not competent?
None, Judge.
All right, sir, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Sorry. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. On your way out of the courtroom today, you need to stop and talk to probation. She's at that desk right over there. All right, we'll see you back at sentencing. Thank you.
Thank you, Your Honor.
Sir, you Armand Gregory. And Mr. Gregory, this is your initial appearance in cause number 26 DCCR 0333. You're charged with the 3rd-degree felony offense of assault, family violence by impeding breath or circulation from January 22nd of 2026. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer? All right, so what I'm going to do, Mr. Gregory, is reset your case for about 30 days or so to give you some time to see if you can get someone hired. If you get someone hired before that next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before that next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the lawyers you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order and you would go back to jail. Do you understand? And I guess you know that your condition of your bond is to have no contact with Shakita Mitchell, correct? So make sure it's very important that means no contact, obviously in person, but also no communication at all in any way through social media or emails or text or anything, okay? All right, step in front of the clerk. She'll give you your reset.
Courtroom drama gets real when emotions, criminal charges, and life-changing decisions collide. If you enjoy intense real court moments and breaking down what really happens inside the courtroom, hit subscribe now and don't miss the next viral case.